Good afternoon. This is Judge Jennifer Brunner from the 10th District Court of Appeals, running for the Ohio Supreme Court in 2020. And this is our series called Achieving Justice. Today, I am so pleased to have to be interviewed today, Marshall Lachman, who is a long-standing, long-time experienced attorney from Dayton, Ohio, who is running for the 2nd District Court of Appeals this fall. I'll let Marshall tell you a little bit about himself and why he's running, and he might even explain to you the breadth and depth of this pretty large-sized district. Welcome, Marshall.
Hi, Judge. Thank you for having me. As you mentioned, I'm running for Judge of the Court of Appeals of the 2nd Appellate District in Ohio. It covers Champaign, Clark, Darke, Miami, Greene, and Montgomery counties. So pretty large area here in the pretty much the Miami Valley. A little bit about myself, why I'm doing this. I've been practicing law now for going on 32 years. Graduated from the Ohio State College of Law in 1988. But my passion for the law started far before that. I come from a family of lawyers. Both my grandfathers were lawyers, and we have a long history of lawyers. So I've always had a passion for the law. And as I have practiced over these last 32 years, I think I've developed a pretty strong knowledge of the law, but that hasn't lessened my ongoing passion for the law. And I think I'm as passionate today about the law as I was when I started law school on my first day a long time ago. I have focused my practice over the last 18 years here in the Miami Valley on criminal defense litigation. And it is something that I have developed, I think, a pretty good reputation amongst my colleagues, amongst judges, for my knowledge of the law, for my willingness to take on the tough cases. I've never shied away from a case. I've done hundreds of trials over my career. I've done everything from in the criminal area, I've done everything from minor misdemeanor traffic cases to death penalty cases. And like I said, it's something that I take pride in the work I do. I think people notice. And as I've gotten to the point to decide what is my next step in my career, having done this for 32 years, and how can I best maybe give back to the community for the knowledge that I've gained, the experiences that I've had. And I think that I have a background, a love for the law, a respect for the law that positions me pretty well to take the next step and become a judge of the Court of Appeals.
Oh, that sounds excellent. So I think people might not understand that for death penalty cases, to be lead trial counsel, someone has to actually be certified by the Ohio Supreme Court to do that, correct? That's
correct. The American Bar Association started a while back, making sure, especially when it comes to someone's life potentially being taken away from them, they set standards that attorneys who are going to be appointed in those cases that they have to meet. And the Ohio Supreme Court adopted rules along with those ABA standards that make it's not easy to become lead counsel certified. You have to have significant experience even to become what we call co-counsel. Every defendant who's facing a death penalty case in Ohio will be appointed 2 attorneys at a minimum. And one is co-counsel and one is lead counsel. And you have to first, even to be able to be appointed as co-counsel, you need extensive experience in handling serious felonies, like just murder cases that don't involve the death penalty. To become lead counsel certified, it requires that you've actually participated in at least 2 full death penalty trials. It's not enough to have handled a death penalty trial that resulted in a plea where maybe someone is serving life without parole but didn't get the death penalty. You actually have to have gone through the process from opening statements through disposition on the penalty phase of a death penalty trial. That is something that I have done. And right now in the 2nd District, in the 6 counties of the 2nd District, I'm one of just 3 attorneys in the entire district who is certified by the Ohio Supreme Court to be lead counsel in death penalty cases.
That's a lot of experience. And I think people might not realize that in a death penalty case, there are 2 phases. There's the the conviction phase, and then there's the mitigation phase, which allows the defendant to put on evidence about why he or she should not be given the ultimate penalty. And that I know from having been a trial judge myself and spending a lot of time with criminal defense attorneys in the process, that there is a lot of study and research that goes into that, isn't there?
Oh, absolutely. You know, it starts, you know, in a normal trial, jury selection roughly takes 2 or 3 hours in a felony trial. Death penalty, both full trials that I have done, it took a week, because not only are you picking a jury that can be fair and impartial in determining guilt or innocence, you are picking a jury that can apply the law, which means applying death penalty if necessary. And believe me, there are a lot of people who come in at the beginning of the process thinking, I'm all for the death penalty. But when you start having that conversation and it becomes that's the person, it's grueling and it's a tough week, and people have a lot of, so it starts with that. And then you put on a trial, pretty much like any other trial. Oftentimes, though, it's a lot more complicated than a basic trial. So those can last a week or two. And then the jury makes a determination. We call it, one word for it is that's the guilt phase. Defense attorneys don't like using that because it's also, we'd say it's the not guilty phase. But it's what you see on, it's the normal trial. Are they, has the state proven the charges beyond a reasonable doubt? Do they find them guilty? But then, like you said, if they find them guilty of the death, what we call the death specifications, if the jury finds that they are eligible for the death penalty, the next step is what we call the mitigation phase, where they decide, is the jury in fact going to recommend the death penalty? And that's where you put on, and as part of the planning of the trial, not only are we interviewing witnesses about what happened, at the same time, we're interviewing family members, we're interviewing teachers, we're interviewing psychologists, we're interviewing people that have known our clients to determine whether or not, what their background has been, what their life has been like. And that's the kind of information you're presenting in the mitigation phase. And then the jury, after hearing that, and that's another trial that can last 2-3 days generally, even longer in some cases. And then the jury deliberates again, and they have to decide the legal way of saying it. Do the aggravating circumstances, does the fact that someone was killed outweigh those mitigating factors that we just presented? If they find they do, they recommend death. If they find they don't, they recommend a sentence short of death, which can include anywhere up to life without the possibility of parole. So yeah, I mean, they are trial cases that usually last well over a year, involve a lot of different kinds of things that you don't face in most cases. Right.
And I think for a juror coming in out of their normal everyday life, it's very emotionally taxing for those jurors. I know as a judge, I realized that part of my role not only was to help instruct and be the best teacher possible, so that I was playing to explaining the instructions in a myriad of ways that people with different learning styles could grasp, but then comforting the jury afterward, because they have to be unanimous on the conviction, and some of them are. It's really easy for anybody to second guess their decision, and it's tough. But I'm looking at that and I'm thinking, a lot of what courts of appeals deal with are post-conviction petitions, which doesn't necessarily stem from the appeal of the actual conviction and sentence, but from something that they can find afterward within a reasonable time that causes a court to look at it again. And it seems like with your 30 years of experience, and it's a variety of experience, I want to get into some of it, you're in a perfect position, having done all this criminal defense work, to really be able to analyze those petitions.
Absolutely. I think, you look at qualifications, you look at, it's an understanding, and as you can get that understanding in so many different ways. But having done what I have done for 30 years, I've seen so many different examples of so many different things. And while you have to weigh each fact pattern as you approach it, it is hard. It's no different than the first trial I did, weeks after I was first sworn in. I didn't understand what the rules of evidence were. It's something you learn over time. And, it takes 32 years of the kind of experience, the issues that I've dealt with, the issues that I've come across, the issues I've had to research, to really have an understanding of what's important, what should be looked at. And in that case, review, and oftentimes those decisions will have been made by a trial court, and just review, was it the right decision, was it the wrong decision? And it requires not only an understanding of the law, but an understanding of how the system works. And that can only come from doing.
Right, right. Now, I really think people would be interested to know that in addition to all these years of private practice experience that you have, you actually were working with LexisNexis, which is what brought you to Dayton, right at this pivotal time when the wireless technology was coming into play, and when legal research started moving from books and CDs to web-based research. Can you talk about that a little bit?
Absolutely. When I was in law school, you had LexisNexis and you had Westlaw, still the two big providers of computer-assisted legal research today. They started online before there was online. It's pretty wild. I mean, the 1980s, we barely had just the PC. There was no such thing as the internet. Then as the 90s rolled around and I went to work, I did a lot of civil work. I did insurance defense litigation. I handled all kinds of different civil matters at the beginning of my career. And when I was hired at LexisNexis, I was hired because of that background to work with litigators, to help them with their research. And then as the 90s progressed and the thing that we now know as the internet was just starting, LexisNexis needed to figure out how we are going to move from this old online, their version of online, to this new thing. People don't need to have a dedicated terminal anymore. They can just go onto this World Wide Web and access the information. And so not only did it require migrating an entire system from one platform to another, it opened up an abundance of other opportunities for, it was an exciting time to be at a company like that. And again, working with litigators. Even then I was working on a daily basis with litigators, creating products for them. And the things we were even able to do in the knowledge management area, taking their own data, things you could never have done before the web came along. We were able to take their own databases of briefs, of information that firms had collected over time, and make that part of the response that they would get when they do a search. Wasn't just the data that LexisNexis housed. And we were making it up as we go along. I mean, I would go out to firms, and because of my background, understanding the things they did, it was a cool time to be there, because we were able to just so broaden what was available to law firm customers that had never been there before.
Yeah, that's phenomenal. And I think about work on the Court of Appeals, comparing it to the 10th District. There's a lot of research that's involved in that. And also understanding the whole business of law and technology and how it meshes. Oftentimes that's involved in business litigation too. And so those complex cases do come to the Court of Appeals, and they're quite lengthy records. So it seems like a pretty good fit to me.
Well, and that's why I say, I have focused the last, 18 years pretty much on criminal defense, but having done the civil side, understanding, I have, been involved in medical malpractice cases in the past before I went to LexisNexis. There's some complex litigation out there, and you need to know how to research it, find the information. It's very hard for any judge to go on the 2nd District Court, any Court of Appeals, and say, I've been involved in every kind of case that's going to come along. And that's where those skills of research, sometimes I'm sure you feel that you're back, got some assignment from your 2nd year of law school on an issue you've never seen before. The longer you've been on the bench, my guess is you don't see it as, but it can happen, and you need to know where to go to find the information. Absolutely.
right. I felt like law school trained us to ask the right questions. And sometimes the more you know, the more you realize what you don't know.
Exactly.
Yeah, yeah. And so so we got kind of this nice balance here with this excellent research and business work in the middle of it. And going back to your criminal defense work, you were awarded the Gideon Award in 2016. Maybe you can explain what that's all about for folks.
Well, like I said, I have dedicated most of my practice to the representation of indigent individuals, either in juvenile court, common pleas court, or in appellate work. I've done an extensive amount of appellate work. But for my work in the Montgomery County Common Pleas Court, where I've done most of my criminal defense work in representing indigent defendants, I was awarded in 2016. They have a Gideon Award, which is for Gideon versus Wainwright, which is the famous case where the United States Supreme Court says that every accused is entitled, if they are facing any kind of jail time or prison time, they are entitled, if they can't afford a lawyer, they are entitled to have one appointed for them. It used to be in some places, it was just if you were facing a death penalty that you could get a lawyer. Gideon had fought to get a lawyer appointed for him. The Florida courts had said, no, you're not entitled to a lawyer. And it wasn't until he got up to the United States Supreme Court, him representing himself, because they didn't appoint him an attorney, he went up and he convinced them that, no, you do have the right. And when he went back to Florida, an attorney was appointed and the case actually was found not guilty. So that's why the Montgomery County Common Pleas Court honors an attorney every year on May Day, on May 1st, on Law Day, I'm sorry, to someone who has exhibited the principles of Gideon. And I was awarded a Lifetime Achievement Award for my work with indigent defendants in 2016 by the court.
Oh, that's truly wonderful. I love the law, and I feel like sometimes I'm the luckiest person alive because I get paid to learn. And that's what we lawyers do. We make jokes sometimes saying, yeah, we keep practicing because we never get good enough. But seriously, that has to be so gratifying to receive an award like that, because I think, ordinary people who aren't really involved with the law don't realize what it's like to represent indigent defendants. Oftentimes you have to go visit them in the jail. And it's not easy to gather your information under some of those circumstances. The witnesses that they may give you to talk to, you have to track them down, and it's a lot of legwork and hard work. And so to get an award like that for what's largely unappreciated time in the trenches has to be a real highlight of your career. That's wonderful.
Well, thank you. It is, and it's like I said, and I don't pick my clients. I am oftentimes the second or third attorney appointed to represent someone because they're having trouble working with other appointed attorneys. And I take that phone call. They look to me to take it because someone has to. And I can't think of a time that I've said no, because it is that important and it can be difficult and there can be issues. You don't always get along great with your clients when you're doing this. In most cases, I have figured out, I develop a pretty good rapport with my clients because I think that's important. But whether you can or can't, they're still entitled to representation of counsel. And it's something that so that's where the pride comes in, is because it's recognition for doing the hard work.
Yeah, that's wonderful. Well, and you've got, you're married, you've got 3 children, only 1 left at home, plus a dog. So what's your favorite thing to do for fun?
We travel a lot, which is kind of putting a crimp in our style right now. Yeah. But we have, my daughter, the youngest, since we've traveled the world. She's been to Peru, she's been to China, she's been to Ireland. It's something that we love to do, and it teaches us about our country. I think seeing these other places makes you, it's something that I learned the first time I traveled abroad right before I started law school. 35 years ago. And when I saw what life was like behind the Iron Curtain, you take those experiences with you, and you learn about what it is to be an American, how important it is, and to bring it back because of the passion I have for the law, how important, how great our system is. But it only works right if everyone is committed. And that's from, in the criminal sense, from the prosecutor to the trial judge to the defense attorney. Same idea in civil with a plaintiff's attorney, defendant's attorney. I mean, our system only works with passionate people. And that's helped me by traveling the world, at just seeing how other places live, how other people, it just creates an appreciation for what we have here and the importance of what we have here.
Yep, and really the rule of law allows for that to happen. And we as judges and attorneys are the keepers of that rule of law. And it's only as good as what people believe it to be. And so when we have that kind of passion, that, provides for the future, actually. So I'm so happy that you could be here today for me to interview you. Would you like to say any parting words?
Well, just thank you very much for the time that you have given me. I'm excited about this opportunity. Hopefully in the next few months, we'll be able to get out to some extent, visit the people in my 6 counties. I wish you the best of luck in your campaign as well.
Thank you. Thank you so much for being with us today, Marshall. And this has been Achieving Justice with Judge Jennifer Brunner and candidate Marshall Lachman for the 2nd District Court of Appeals. Thank you.